Hello, I'm Andrew Flushy. I'd like to talk to you about a result from court a few days ago in Spotsylvania County. Before I do that, let me give you a notice required by the Virginia State Bar that every case is different. Every case depends on the facts and the law of your case, and past results don't indicate future success. With that out of the way, let me tell you about a case from Spotsylvania County. I had a client who was charged with passing a stopped school bus. He was charged under just the traffic version, 46-2-844. That version of the law says basically that it's a traffic infraction to pass a stopped school bus, and anybody doing so will be fined. And the law sets forth a whole bunch of requirements of what the Commonwealth has to prove to make the case. Basically, they have to prove that the bus was stopped, that the lights were on, that the bus was yellow, it says school bus, that it was actually loading or unloading people, quite a few things like that. There's lots of little things. It makes it a hard case for them to prove just because the officers sometimes forget a piece when they're testifying. But in this case, there's actually a very fascinating flaw in the law that we were able to use to get the case completely dismissed. The current version, there's two versions of passing a stopped school bus. One is the one my client was charged with, 844. The other one is a reckless driving version, 46-2-859. What that law says, basically there's an error in it, or there was at the, prior to March 22nd of this year. So the law basically says that any person who fails to stop a school bus is guilty of reckless driving. They're missing a key word, either for or at or some other language. It's just a grammatical error in the statute. And so it basically makes no sense, and it's almost just a nullity. It just doesn't really matter. It doesn't really criminalize anything. Well, that law has since been changed. The legislature this past session passed an emergency amendment to the law, and they've cleaned it up, and the reckless driving version is very solid now, effective March 22nd of this year. But in my case, the offense took place before March 22nd, so we were dealing with the law before it was amended. 844 doesn't have the flaw like 859 does. However, 844 does incorporate 859. So if you follow me, what the law that my client was charged with says is that you're guilty of passing a stopped school bus if, in violation of 859, you do all these things. So you have to violate the flawed statute in order to violate the statute that my client was charged with. And so what that basically means is that my client was not guilty because the statute had a flaw, and the statute that she was charged under incorporated that flawed statute. And the judge rightly dismissed the case. This is one of those kind of little complicated legal arguments. You have to very closely read the statutes at hand. And even attorneys, we read the statutes over and over and come up with these new ideas and seeing these new flaws in the law that are able to help clients get good results in court. Now, as I said at the beginning, every case is different, and we always have to look at the facts of the case and the law at hand. And that's one reason we do review the law, so we can see if maybe there's something we just haven't seen before or something new that might have come up, and maybe the law's been amended and they've made a new error in it that could help you get a good result in court. So it always pays to talk with an attorney and have an expert on your side who can look at the law and see if there's something at hand that could help your case.